Hey guys, welcome to our video. In this video, we'll answer this question. Can you be served with a summons even after you've challenged the jurisdiction of the court? And so the summons is what goes with the complaint or the lawsuit. And the summons tells you you have X number of days to respond to this lawsuit. So normally you would be served first and then you would challenge the jurisdiction of the court. But you might also know that somebody is suing you, they haven't yet served you, and you go challenge jurisdiction of the court. So after you challenge the jurisdiction, can they still serve you? And the answer is yes. So the jurisdiction has to do with the power of the court. And you can challenge that, and unless a judge says, all right, don't serve, which I've never seen that before, but a judge could do that, then the other side can still serve you. Now, if there's no jurisdiction, then the lawsuit's going to go away, okay? But while that battle's being fought, they can still serve you, again, unless the judge tells them otherwise. So, everybody that files an attack on a lawsuit, it might be a motion to dismiss or motion for summary judgment, whatever it is, of course, in their mind, they're like, well, clearly I'm going to win, so we should not do anything else with the case. But the other side generally feels just as strongly that you're not going to win. So normally a judge will let things go on while there is a challenge here. And I just want to take this opportunity to address, what does jurisdiction mean? So I said it's the power of the court. There's really two types, and there's other ways to sort of divide this up, but this is the simplest way. There's personal jurisdiction, subject matter. Personal jurisdiction is power over the parties. So here's what that means. Let's say that you're being sued in North Dakota and you've never lived in North Dakota. You've never visited North Dakota. You've never done business with anybody in North Dakota. Well, and while it can get a little complicated because there are all these different tests that we do called minimum contacts and other things, but just take it at face value. That North Dakota court is not going to have power over you because you're not subject to the jurisdiction of that court, because you've never been to the state, you've never touched the state, you've never done anything with the state. Now, the person suing, it sort of automatically subjects themselves to the jurisdiction. So let's say that you live in North Carolina and you want to sue Midland Funding, national debt collector. You want to sue J.B. Hunt, a trucking company, and you want to sue them in Alabama. Well, the court obviously has power over you because you voluntarily came to the Alabama court. And what about power over this national debt collector, this national trucking company? Well, then we would look and say, did the lawsuit arise out of a contact with the state in Alabama? Well, if you're in North Carolina, probably not. But if it didn't, then does Midland Funding, does J.B. Hunt, UPS, whatever it is, are they just widespread contacts in the state of Alabama? Well, the answer is yes. So you could sue them here because the court would have power. The court would have personal jurisdiction over those companies. Now, the other type of jurisdiction is called subject matter jurisdiction. And that's really the power over the subject of the lawsuit. So give you an example. There are certain things having to do with maybe probating a will that you cannot bring that in small claims court in Alabama or district court in Alabama or even circuit court in Alabama. You might have to go to the probate court because that has exclusive jurisdiction over certain things. There might be a type of lawsuit, let's say an eviction or what's called an unlawful detainer, where that can only be brought in a certain court, not in other courts. And so there are some courts that are called general jurisdiction. So basically you can bring any type of suit there, and then others are limited. So for example, federal courts have limited jurisdiction. So you either have to show it's a federal claim or there's what's called complete diversity between the parties. Means if you look at sort of both sides of the V, Smith versus Jones, then there can't be any overlap in the states, and it has to be over $75,000. So either that federal question, federal subject matter, or diversity. And the point with this is not to try to explain every detail and exception and all that, but just to say jurisdiction is power of the court, either over the person or over the subject matter of the lawsuit. And so when that's challenged, the court has to take that very seriously, because if it has no jurisdiction, then anything it does after that is meaningless. Okay, so but if you challenge the jurisdiction and they're still out trying to serve you the lawsuit, unless the judge tells them not to, it's okay for them to serve you. And then you have to get with your lawyer to decide, okay, do I respond to this lawsuit? Can I just sort of rest on my challenge to the jurisdiction? And that varies by court. So anyway, I hope that this is helpful. And if you have any comments, just put those below. Okay, thanks for watching. I'll catch you in the next video. Bye-bye.